Hello, welcome to CHI Borders video. My name is Ko Fujimoto. I am going to talk about the concept called domicile today. So this concept is very important for US gift and estate tax purposes especially for non-citizens. So I'm going to focus on the case for non-citizens, primarily green card holders. Why I make this video today, it is because the residency for the US income tax purposes is strikingly different from the residency or domicile. They use the word domicile for US gift and the estate taxes. So if you're a green card holder, regardless regardless of where you live, as long as you have not abandoned or you took up a step to giving up your green card, you are US resident for the US income tax purposes. Therefore, you need to, or you still have a obligation as a US resident to report your worldwide income to the IRS. For US gift and estate taxes, some people may be able to understand it better if I use the word inheritance. The concept is different. So even if you are a green card holder, or even if you are a resident for the U.S. income tax purposes, you may not be a resident for the gift and the estate taxes, and that makes a huge difference. And the difference comes from the concept of domicile. Okay, so the domicile has two requirements. In order for you to be a U.S. domicile, there are two requirements. One is actually living in the United States, which is relatively easy to prove, right? The difficult part is number two. The number two is your intent, your intention of permanently living in the United States. That's my intent. That's what I will do. That particular intent is a requisite or requirement for you to be considered as a US domicile. And you don't know my intent, what I am going to do after I take this video, right? Because if I don't publish my intent of my plan after taking this video, so that really means that intention is, it's very hard to prove, right? Hard to prove, hard to counter-prove the intention. So, if you are really scrutinized, or if you get nailed down about your intent by a third person, the third person do need to, because they cannot open up your mind and lead it. Therefore, different facts, circumstances are the things that third party, especially for the IRS, will use to determine if you're domiciled or not a domicile. So the factors are it's not the complete listing. It's really okay. Where do you have a physical living space or house, or where is your business? Where are your families? How long you live in the United States, or do you have a green card or not? And you may have made certain statements in tax returns or communication with banks and your will. Those the evidence, the gathering all those evidence and make a judgment is number 2 criteria of domicile, right? Your intent to permanently live in the United States. And the recently, because of the COVID, people could not travel, right? So let's say I have the intention to live in the United States, but I was visiting Japan. And because of the COVID, I could not come back to the United States, but my intent was there. I have a home in the US and I have my family there. Unfortunately, I passed away in Japan. In that case, from the US tax perspective, I think I have a good chance to be considered as a US domicile, right? Let's say I am a green card holder. So this is the type of discussion that you need to go through with international estate or trust and estate expert to determine your status, and that depending on the status, your plan for the future, or your plan for future gifting, or your plan for future wealth transfer would be very, very different. So you have any questions, or you want to discuss with me one-to-one on the online setting, please feel free to take advantage of half an hour the online complimentary consultation with CHI Border. So thank you for watching and have a wonderful day. Thanks.